Thank you. Good afternoon. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dill, and I'll be presiding today. To my right is Judge Valerie Zachary. To my left is Judge Hunter Murphy. We have one case on the calendar. It's Berens versus Berens, and so if the parties are ready to proceed, you can make your argument. And let me know if you want to reserve. You can go ahead and take the podium, but let me know if you want to reserve any time. There is a clock there. I don't pay. It's not the gospel. So if we're firing questions and stuff, I'll always allow you a little bit of time to wrap up and whatever. But I mean, the clock is there. But I'll also give you some warnings if you need it.
Thank you, Your Honor. We're planning on reserving 7 minutes for rebuttal.
7 minutes, okay.
And also, I know sometimes it's hard to hear me with the mask on and the microphone. So if you can't hear a question, please just let me know that.
All right.
Happy to try to repeat it.
Thank you, Your Honor. May it please the court. My name is Troy Shelton, and I represent Melissa Berens, the mother in this case. With me as co-counsel is Michelle Cannell. Ms. Cannell and I will be dividing the argument today. I'll first be addressing the lead issue in our brief, which is whether the trial court erred in violating the mandate rule and in modifying child support retroactively. Ms. Cannell will then address the balance of the issues that we've raised on appeal. In his brief to this court, Mr. Berens has blamed everyone for his failure to have his child support reduced. He blames Ms. Berens for exercising her right to take appeals. He blames the trial court for taking too long to enter a permanent support order. And he blames this court for telling him to file a new modification motion in this court's 2020 opinion. Mr. Berens is blaming everyone but himself, but the situation that he finds himself in is one of his own making. In the last appeal, this court instructed that on remand, quote, husband may now file a motion to modify support in light of another child reaching the age of majority. The issue of retroactive child support can begin and end with that sentence in this court's 2020 opinion. Under the mandate rule, both the trial court and a subsequent panel of an appellate court are bound by a prior appellate court's resolution of an issue. Here, the parties disputed the age-out issue before this court, and this court resolved that issue in favor of Ms. Berens. But on remand, the trial court ignored this court's instruction, allowed Mr. Berens' prior motion to serve as the request for modification, instead of requiring him to file a new motion, as this court had instructed. Ms. Berens complains that this court should never have written what it did in the last opinion because it was dicta. But it was not dicta. When Mr. Berens appealed from the 2018 permanent support order, his lead argument was that the amount of support was incorrectly calculated because one of his kids had aged out. The court rejected that argument because Mr. Berens had failed to put the age-out information into evidence. Mr. Berens asked the court to ignore the lack of evidence and decide the issue for itself as if it were a trial court. And the court did recognize that Mr. Berens had filed a motion to modify a temporary child support order. But the entry of the permanent support order superseded that prior temporary support order that Mr. Berens had moved to modify. So the court correctly rejected that argument too, saying that Mr. Berens, if he wanted that relief, needed to file a new motion on remand. Under the mandate rule, it doesn't actually matter whether this court got it right or wrong in the last appeal, but this court did get it right. Mr. Berens was trying to modify the earlier temporary child support order. That temporary order was superseded by the entry of the 2018 permanent support order. That means the temporary order was no longer modifiable.
Well, let me ask you a question regarding that. And let me give you a hypothetical. My wife and I get divorced, and a trial court judge enters an order which is based on terrible law or whatever. Judge Dillon, you got to pay $1 million a month for the next 6 months, but we're going to come back in 6 months and have the permanent hearing. I immediately file, a motion. No, I want to appeal that or do something, but it's interlocutory. And then the trial court 6 months later enters a permanent order, says, going forward, you're going to pay $1,000 a month. How do I challenge that $1 million a month payment? What can I do?
I think you have a lot of options. First, you could try to notice of appeal. You could try to file a petition for writ of certiorari. You could also file a motion to modify immediately as soon as that order comes out.
But then my motion to modify would be to modify the temporary order, and if the court doesn't take it up, it enters the permanent order, what do I do? I mean, so if the court enters a permanent order and says, I'm not going to consider that, as was done in this case, what should have the father done in this case? If the judge takes a year to enter the order and there's a change to circumstances, how do you protect your right, is my question. So what should this father have done in this case to be able to go retroactively back to when this child turned 18?
I think that is the crux of the issue. And there are 5 things that Mr. Berens, under the facts of this case, could have done, but that he didn't do. So, and I want to catalog those. First, what he could have done was what Your Honor pointed out in the last appeal. He could have actually put the age-out evidence into evidence. So, you know, if he had done that, we wouldn't be here. So,
At what point could he have done that? That's one part, you know, I just subbed in on this case yesterday, so maybe I'm missing part of the procedure there, but what part could he have actually been heard on that prior to the entry of the permanent order?
Had that child aged out at the last hearing?
So at the time of the hearing, when the hearing was occurring, the child had not yet aged out, but the age out was coming up. So he could have gone ahead and put that evidence in had he wanted to. But that was just the first option that he had. The second option that he had was the moment the age out occurred, which was after the hearing had ended, but the order had not been entered, he could have filed a motion to reopen the evidence at that point in time so that the age out evidence could have been introduced. Third, after the permanent support order was entered, he could have immediately filed a written motion for retroactive modification under the compelling reason prong of NC Gen Stat 50-13.10A2. You know, that's the anti-retroactivity statute. That's really at the core of this case. And under that statute, Mr. Berens hasn't argued that he complied with it. He isn't arguing that he falls within the exceptions, but he could have fallen within one of those exceptions. That statute says that if you're precluded for some reason, after your payment comes due, if you can't move at the time the payment comes due, then immediately after you're no longer precluded, then you can file a written motion for retroactive modification. That's exactly what Mr. Berens should have done in this case, and he could have gotten the retroactivity that he's seeking. And he didn't do that. But that was only his third of his 5 options. After that, as soon as the permanent order was entered, he could have taken a more parochial route. He could have filed a motion for reconsideration under Rules 59 or 60. The Rule 59 motion would have been due 10 days after the order was entered. And he could have paused things right then for the court to hear that new evidence. He didn't do that either. Finally, at the bare minimum.
Well, on that one, if it's reconsideration, it'd be reconsideration of the status at the time of the hearing, not at the time of the order, right? So tell me how that prong could get him the relief sought based on turning 18 after the prior hearing.
So Rule 59 allows for you to come in with new evidence that you couldn't have presented earlier. So he could have said, well, I couldn't have presented this information earlier. I didn't know it was going to take you this long to enter the order. So Rule 59 and Rule 60 would have let him do that. But he didn't file either of those motions either. So his 5th option, which is really the simplest thing they could have done, was as soon as the 2018 permanent support order was entered, he could have filed a motion to at least modify it prospectively. And then we'd be talking about an overpayment of maybe $3,000, not an overpayment of $40,000.
Well, if this court were to vacate or remand that part of the court's order with regard to child support, could he go back now and file a motion to modify, within the exception, the retroactive child support compelling reason exception, and take care of it that way?
I think maybe the cleaner issue would be for the court to say, we'll take your supplemental motion, which we don't really think was particularly proper when you filed it in 2020, and we'll at least give that perspective effect. But he couldn't now go back, even under the anti-retroactivity statute, and file and try and modify all the way back to 2018, because the statute requires you to file that written motion promptly after you are no longer precluded for seeking retroactivity. That was 4 years ago. So I think under any reading of the statute, 2022, no longer prompt.
What if he had done everything you said? So the child turns 18, he'd filed the motion to reconsider, he filed the motion to reopen the evidence, and the trial court just says, deny, 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 I'm just going to enter a permanent order based on the evidence that was before me last summer, what could he do then?
That's when he could have filed the motion for retroactive modification as soon as the permanent order was entered.
Well, but he's, okay, what if the judge took another 3 years before entering? I mean, he's lost those 3 months. He's entered, the child turned 18. I mean, what about the intervening 2 months? I'm just trying to think, what could he have done? The child turned 18 in March or whenever it was, and then he filed his motion, and he filed all his other motions. The court says, I'm just not going to hear any of it. And entered her order in the summer. You know, has he lost his right to appeal, to at least ever claw back to get those 4 months?
No, he wouldn't, Your Honor.
So what was he do? What would we do? He's done all this reconsidering the judge and the discretion. I'm not going to consider any of it. There haven't been any hearings because you're just waiting on the judge to enter the order. The judge doesn't even take those motions up. I mean, just won't even consider them. I guess you could notice a hearing or try to, but you can't get on the, I don't, for whatever reason, the judge waits a month or two and then finally enters, even if it's just a month later, you know, and so you're never heard on your motions or whatever. What do you do to get, is there anything you can do for that month?
Well, you know,
Or are you just lost because the judge entered a permanent order and that just cuts you off?
you're definitely not just lost, Your Honor. So under the anti-retroactivity statute, it sort of understands that there might be a big gap between the filing of the motion for retroactive modification and a hearing and a decision. And so you preserve your rights so long as you file the written motion promptly after you're able to do so. Once he had eventually gotten a hearing on his motion for retroactive modification, had he filed such a motion, then if that were denied for whatever reason, the trial court misunderstood how the anti-retroactivity statute works, he could have then appealed from that order, denying that modification.
So did the father file anything after this permanent order was filed? Was there something he filed that you said wasn't good enough? I'm trying to remember the fact.
Yes and no. So in 2018, nothing. Permanent order is entered, appeals are noticed. He never files a motion. Standing here today, he still never filed a motion to modify the permanent support order.
Yes, we sent it back. It's when we sent it back.
That's right. And still then, only on the eve of the trial, not on the eve of the trial, on the first day of the trial, he makes an oral motion under Rule 15 D saying, please let me file a supplemental pleading. Let me supplement my motion to modify the temporary support order. And there are lots of problems with that effort.
Before, it sounds like you might transition to that, but before you do, I just want to ask kind of how this interplays. Let's assume that we disagree with you and think that it's going to relate back. If the mandate rule comes into play to block him from going all the way back, can the supplement, why wouldn't the supplement at least date back to the date of our mandate in Berens 4?
I think the supplement, so the problem with the supplemental.
More or less, I mean, I'm not looking for a resolution here, but it more or less would split the baby kind of in half, looking at a timeline. You'd go back to whenever this was in our decision in January of 2020 and say, okay, he files the supplement, we're going to let it relate back to the prior motion to modify, but because of the mandate rule, we're not going to go back before January 21st.
I think the problem with doing that is the anti-retroactivity statute. The time at which you could split the baby would be the filing of the supplemental motion, supplemental pleading, which happened in September 2020. So you could say, okay, we are going to prospectively reduce child support starting on that date, but under the anti-retroactivity statute, you have to have a motion. And so there was no motion filed when the mandate came out. So you couldn't date it all the way back to that point in time, because then you'd be violating that statute. And that statute, of course, is mandated not just by the General Assembly, but by Congress.
Well, the way I was reading the federal legislation, at least, it was just about being put on notice, wasn't it? And here, there's no doubt that at least, the appellant was on notice that he's looking to modify based on this.
Well, notice of what? I mean, the problem was he filed the motion to modify.
Notice there was a change of circumstances on the fact that the child turned 18. I mean,
Sure.
There's clearly notice. I mean, I would think.
I mean, of course. I mean, Your Honor. The kids living with her. All the kids live with her. So of course she knew when they were graduating from high school.
And she was on notice that he intended to modify this based on the child aging out. And that, looking at the federal legislation, that seems to be all that's required under USC 666A9C that you cite on page 14 of your opening brief.
Yes, the state statute, which is the one that's more clearly at issue, requires more than just notice. It requires a written motion and notice. And so when he filed, and on the first day, well, he didn't file it. When he made it, his attorney made an oral motion for a supplemental pleading, it was oral. So it violated the written motion requirement of the anti-retroactivity statute. And because it was oral, there was, of course, no notice. And we objected to the lack of notice, as we noted in the transcript.
Was your client prejudiced by this in any way?
Prejudiced by the fact that she's having to make the repayment, but there is no prejudice inquiry under the anti-retroactivity statute. You know, that my friend on the other side and the trial court have both raised the prejudice issue, but this is a very technical statute. When it says if and only if, and here are the exceptions, there's no, well, unless you're just not prejudiced. You know, the General Assembly could have written that.
So your client did get notice, and a motion was filed. So what's the problem?
It was a motion that could never have been granted, was the problem, because the motion was to modify temporary child support, and that motion couldn't be granted because it was superseded by the permanent support order. And all Mr. Berens had to do to get the exact same relief was the moment that permanent support order came down, file a motion under the compelling reason prong of the anti-retroactivity statute. My friend on the other side was just not engaged with that statute because that statute is very clear in the way that it's written, and he doesn't meet any of the exceptions, but he could have met that exception had he just filed the written motion.
Now, sorry, child support is a creation of common law, not statute originally, correct?
My understanding is that it's a creation of statute, or at least today, it's in control of the entire.
It's typically controlled by statute now, but originally, you know, there was a common law duty to support your children, correct? Or at least for a man to support his children.
I believe that's it. That's my
So
understanding.
would these statutes be in degradation of the common law, or do they completely supplant the common law principles?
I think the common law principles has been supplanted a long time ago because, as you just suggested, Your Honor, under the common law, Ms. Berens wouldn't have had a duty to support her children. In fact, but when they divorced, she didn't even have a job. So he would have had, you know, hey, if we're talking just about common law, he's the only one that would have had the duty and not her. I want to touch on the problems with the supplemental motion. So this is, you know, the first argument is the mandate rule, the second argument is the anti-retroactivity statute, but the third argument is he couldn't get this relief through a Rule 15 supplemental pleading. And there are at least three problems here. The first and most importantly, the motion didn't comply, as I said, with the anti-retroactivity statute because there was no motion, no written motion, and there was no notice. Second, the motion was improper under Rule 15. You can only use Rule 15 to supplement a pleading. You can't use it to supplement a motion. He was trying to supplement his motion to modify temporary child support. And third, the motion didn't comply with Rule 15 because it wasn't supplementing anything, and it couldn't relate back to the earlier motion. As Rule 15D says, a motion to supplement is for new transactions or occurrences or events which may have happened since the date of the pleading sought to be supplemented. But Mr. Berens wasn't trying to supplement anything because the age-out had already occurred when he filed the motion to modify the temporary support order. Instead, what he was trying to do was breathe life into that old motion. But that's impossible for a supplemental pleading because the supplemental pleading is supposed to be saying, I'm now giving you notice of new things as of the date of this pleading. And under Rule 15C, and this is really the crux of the retroactivity problem for him for Rule 15, that only amendments under Rule 15, A, B, and C talk about amendments to pleading. Rule 15D talks about supplements to pleading. Only amendments to pleadings relate back to the original pleading. Supplements do not relate back. 15C says only the amendments do, which makes perfect sense, because why would a supplemental pleading relate back to the original? It's supposed to be about new events and occurrences, but here, nothing new had happened.
Just be aware you have about 12 minutes total left, so if you want to leave.
Does it have to relate back if he fits within the exception on the retroactive modification rule? Does it have to relate back all the way? I mean,
Yes.
if he meets the compelling reason exception.
I think that he'd still have the separate. If he wants to hang his hat on his Rule 15 motion, then he would need it to be able to. He'd have to comply with Rule 15, and since it doesn't, it can't relate.
So it just needs to relate back for the supplemental pleading, but not in order to be able to get retroactive modification.
Yes, even, Your Honor, if you were to say, you know, I disagree with you, Mr. Shelton, I think supplements relate back for some reason, okay, well, you still run into the anti-retroactivity statute, which would would control. So he needs to be able to walk through both of those doors, and he can't get through either one. I don't want to waste any more of this.
One more question regarding the mandate rule, just so I understand the procedure of Berens 4 was the last one up here. When that was up here, I know the opinion notes that there's some discussion in the briefs about that motion having been filed.
Yes, Your Honor.
But there was never an order on that motion. And typically, we don't address in opinions or our discussion order or motions where the party hasn't actually gotten an order from the trial court. So did we even have jurisdiction to really talk about that and therefore invoke the mandate rule?
I think you absolutely did, Your Honor. I mean, he raised that issue in his brief. It was his lead argument on appeal. He was the one letting you know that he had filed that motion. And, my friend on the other side has made a lot about mootness, but you can call it whatever you want. Call it a superseding, his motion's been superseded. And we filed in our memo of additional authorities a case called Woodring. In Woodring, this court held that the trial court erred by modifying a temporary support order when it had already entered a permanent support order. And the court explained, once the permanent support order is entered, only it can be modified because the new order, quote, superseded the old order. So I think the Woodring case, I think helps address your question. I think that when Judge Dillon, when he wrote that, just had a very commonsensical, to me, that's how it reads to me, a very commonsensical approach. Of course, you're going to have to file a new motion because that old motion is no longer grantable. As this court said in Woodring, it was error as a matter of law to go back and modify the temporary support order. If the court has nothing else for me, I'd like to yield the rest of my time to my colleague.
And you got a little extra time because of the questions, so.
Okay, and I was going to say, I will just reserve it for rebuttal unless I have an extra minute.
Just you ignore the clock. You can have an extra 2 or 3 minutes. Go ahead. We're fine, and I'll give you more time too, because I want to make sure our questions get answered because there's a lot of issues. So go ahead.
No, thank you so much for the extra time.
I'll tell you when you eat into your 7 minutes. So you got at least 3 minutes. So go ahead.
And I was going to address the remaining 4 issues, but let me just do these 2 and a half. Part of our argument is that there was not sufficient evidence presented at trial to make the findings of fact that were made by the trial court. And in response to that, the appellee has argued that there was an incomplete transcript, and therefore we could not make an insufficiency of evidence argument. And I would just like to point out the facts that led up to the transcript, just so we'll have that clear. And it is true that the appellee has the appellant has the responsibility of providing the record on appeal and making sure it's correct. But the appellee also has the responsibility to make sure that the record.
Let me ask you a question. So you're going to argue the court let's say the trial court judge found that, I was driving a blue car, and you include a bunch of the transcript, and there's nothing in the transcript that talks about the blue car, but you don't include the whole thing. Does that mean that we can't consider it because you didn't include the whole transcript, or is it incumbent upon the appellee to say, wait a minute, I want to make sure you include this part that
No, and I think under that situation, no, sir. I think that I cannot leave out part of the transcript and then say, well, it wasn't in there. And those are the cases that are cited in their brief, the McKyer case and the Gill-Martin case. It was clearly half of the trial was not transcribed. In this case, though, however, we requested a full transcript with our documentation. We served the transcript that we received with the proposed record on appeal and said it was the full transcript. The appellee then reviewed the proposed record on appeal and, in fact, looked at the transcript, which is only about 225 pages long, and stated that it asked for revisions to the transcript and said, could you please make these revisions to the transcript? So clearly had read the transcript when reviewing the proposed record on appeal. Those revisions were made, and then, so there was no narrative, no judicial settlement, but then when we settled the record on appeal, the parties stipulated that there was a complete copy of the hearing transcript included. And so with that stipulation, there should be no other questions about it. And it wasn't until we read the brief that this came up that, well, it's not a full transcript. Okay. So we would rely on the stipulation of counsel on that. With regard to Ms.
And I think there's a criminal case similar on point where we held the state to that standard when they stipulated to either a narrative or a partial transcript in the past. Would that carry over into the civil context as well?
There is the NRA RN that's cited in the memorandum of authority relied on criminal cases and with that effect. And it basically required that both parties, you can't sit on your laurels and then do a gotcha afterwards, for lack of a better word. With regard to Ms. Berens' income, whether it's investment income or her working employment income, the evidence was speculative. The findings of fact that were made were based on speculative evidence. Ms. Berens is a real estate agent, and her financial affidavit that was submitted to the court for 2020 says that she made about $3,300 a month gross income. And then the trial court found that she made almost $18,000 a month gross income. And that was based completely on Mr. Berens' testimony. Mr. Berens' testimony was that, and he relied on, well, let me back up. The Lasecki case states that you cannot make findings of fact based on speculation. They have to be competent evidence. Mr. Berens made a chart which had Ms. Berens' financial affidavit income and then what he thought more accurately reflected her 2020 income and her 2019 income. And he stated that he looked at Zillow.com and he looked at the houses that he thinks that she sold.
And then he took a percentage, yeah.
Right, and then guessed at the commission she would have sold. So he was guessing based on Zillow, basing at what she sold, how much she got
There's
for that.
something in
and the
their brief,
commission.
though, that I'm remembering, and I have to go back and look at this, that said that, well, he got within 6,000 of the correct figure. What's the correct, what was that based on? What was the correct?
I think that he,
Was there some
we have
evidence
to
in there
match-
that was there some, I think it was like, he guessed it was 147,000 a year, and was there some evidence that it was really 141,000? Because you're saying the income is 33.
that was grossly off. No, I think that, I believe, and I will let my friend speak to that, but it
Okay,
was
that's
based on the bank accounts that he maybe
I mean, I don't disagree that just going off of Zillow and guessing, because you don't know what the percentages are, because some houses get sold at 2.4%, 3.6, all over the place.
Right.
I get that, but I'll let them speak to what evidence
Okay.
there was in there. Okay, go ahead.
And then the investment income was the other issue that the trial court specifically said that we're going to give you 3% return on this. And that's contrary to the Gatlin case that we added in the back of our brief that says you can't speculate on the amount of return that someone's going to get on whatever investment monies you have. Gatlin, in that case, it was a CD, and the trial judge, that was returning like $300 a month. And the trial court said, well, I think, with the market today, you should be making a lot more than $300 a month, and so I'm going to impute whatever amount to the mother in that case. And that's the same thing that happened here. There was no evidence of any kind of return. In fact, what I can find is that the trial counsel there said, I need you to calculate a reasonable rate of return on that $650,000. And that's what the trial court did, just picked out 3% apparently. And that would be speculation. At the risk of overstepping my welcome.
Now, I do want to hear a little bit about the 529 account real quick.
Okay.
If that's what you were going to talk about.
I was going to talk about the UTMA and the 529, but either one that you want me to talk about. I think all we really need to know about those two accounts is that the way Mr. Berens and the trial court thought about it is the way it was summed up, and I know this is just argument, but the way it was summed up in closing by the trial counsel, it says, and then there are the UTMA accounts. You could literally strike everything on the children's individual expense sheet and say the 529 money that the parties funded during the marriage, Mr. Berens effectively prepaid his child support. And that's just contrary to law. UTMA accounts are the property of the children, and this court has repeatedly held that you are not, a parent cannot be, his child support can't be diminished or otherwise.
Let me ask that. Okay, so say before the divorce, before the hearing, the father had given one of the children a car, and now they're 16, but the child wants to retain the value of that car and not do the mileage. Could the trial court find it not necessary that the father contribute to a car payment for the child? For a new car or a new used car, just because the kid wants to hold on to the value in that car that he already has?
I don't think I understand the
So
question.
if dad gives the kid a car before the hearing, even before separation potentially.
Okay.
So it's titled to the kid has a car, has transportation, get him to school, get him to whatever events. Then when they're coming back and saying, what's a necessary expense for the child? If the mother asks for there to be an additional car payment for the child, because they're not going to use that other car, why can't the trial court take that into consideration that the child already has an asset for that use and not think it's a necessary expense at that point?
Well, I think that sort of goes into ED law at that point, because that car asset is actually a marital asset, and so then.
Okay, let's say
that.
grandpa gave it to him.
Okay, right. And so it's a child, I think that, again, is that a reasonable expense is what it comes down to. I mean, the father is not obliged to make a car payment under the child support guidelines. But, and in this situation, father, Mr. Berens, is obliged to make child support payments. And our courts have held that he can't get away from not paying it if he has the ability to pay. That's the exception.
Did the trial court allow that money to be used for any purposes or only to take away from educational purposes?
And
Just to remind me in this case.
in this particular case, the trial court directed that the UTMA funds be used to pay the tuition and car insurance.
Is it possible that that was a typo with regard to the private school expense? Because that's a qualifying expense for a 529 account, right?
Right, and I believe the 529s, I don't know if it was a typo or not. I know that you're correct, the 529s can go to education now in this situation. And the 529s were a marital, that's a marital asset that was distributed to mom. I'm not going to argue with you on that point, that's a valid expense. But with the 529 account in this particular case, it's really unclear what the trial court was doing. One, we're never quite sure what the amount was on that 529, but also at some point the judge says, well, you could take the money and invest it, and then there's this 3% thing. So are we taking the 529 out of the account and we're having to reinvest it, or is that reinvest? So the 529 account at best is a little bit murky. And then if the trial court is, if it's being directed to pay just child support, then there's going to be taxes and penalties associated. But again, could go to a tuition. But that's not the case with the UTMA account. And if we allow the judge to direct the UTMA account to be paid for a specific anything, what that says is that the children who are a non-party, any trial court can tell a non-party to make payments from their own separate account, and this point is more egregious because it's a minor's account, and I think that would be a terrible precedent.
But couldn't the court have also said, well, I'm just not going to consider car insurance to be a reasonable expense in
Yes,
this
ma'am.
case?
Thank you.
Thank you.
And you have 30-plus minutes, whatever it is.
Thank you, Your
I just
Honor.
make sure we get through all the issues because this had a ton of them.
I need to arrange all my stuff here real quick.
Yeah, take your time.
May it please the court, counsel. My name is Preston Odom, and I practice law with James McElroy and Deal in Charlotte. I also, along with my co-counsel, Gina Morris, who couldn't be here today, we represent the plaintiff appellee, Mike Berens. The court knows this is the 5th time that this case has been before the court, and it's actually the 6th appeal that's been before this court. In Berens 4, this court was dealing with cross appeals from the permanent order that was entered by Judge Blake on July 20th of 2018. And Mr. Shelton, leading off, said that one sentence of that opinion in Berens 4 really controls this case. And respectfully, we believe that is a drastic overstatement of what this court actually said and what it meant in Berens 4. So in addressing the subject matter jurisdiction issue that was actually at issue in Berens 4, what this court said is, because there was testimony and evidence from May of 2017, upon which the court then, 14 months later, after being compelled by writ of mandamus to enter an order, the July 20th, 2018 order was based on evidence from May of 2017, when there were 3 minor children, not 2. The trial court had subject matter jurisdiction to award child support for 3 instead of 2 minors in the permanent order that was before the court. The motion for modification that my client filed 4 days after the party's child, third youngest child, aged out and was emancipated, was not, the validity of that motion was not before this court. Ms. Berens' counsel actually argued several times in both responses to the mandamus petitions and also in the briefs that the validity of the modification motion was not ripe for review, and that it had to be something that would be addressed by the trial court afterwards.
Well, let me just hypothetically, I'm not going to really think of a real hypothetical, but, you know, I wrote it, and I don't know what I meant by it, but I mean, but sometimes we'll say the trial court cannot take evidence at a new hearing, and, you know, and that's, I don't know if there's any rhyme or reason when we say that and when we don't say it, but if I said it, whatever I said, and whether we had, you know, I mean, whether, unless it's a subject matter jurisdiction, whether, you know, we should have addressed it or not, if what I said really means that the only way you can get at this is to file a new motion, and I was wrong to do that, but you don't ask for, hey, could you modify that order or, you know, reconsider at least that part of it, I mean, whatever I write becomes law of the case. But so I want to hear, like, a little bit, why is that sentence just doesn't mean anything? I mean, you know, because assuming you may be right that that motion wasn't for us, but I mean, maybe nobody asked us about whether you can take evidence or not. We just kind of say something, and sometimes we do say stuff.
Sure, Your Honor. I don't think that the sentence means nothing, but at the same time, you can write a sentence in an opinion and it not be a holding and it be dicta. And in this instance, when there's actually not a ripe issue before the court, and the court talks about the unripe issue, anything that the court says on that unripe issue is by definition dicta. And interestingly, this is not a directive to the trial court. It's a permissive, the father may file a motion to modify. It doesn't direct the trial court to do anything. Thus, the mandate rule in that instance is a misnomer because it's not mandating the trial court do anything. The only mandates from this court in Berens 4 were set forth at the end, where it talks about the reversal and remand for the trial court to include Ms. Berens' received and reinvested dividends in her income for alimony. And then it, in the closing sentence, says the trial court properly exercised its discretion in all other portions of the permanent support order, which was the only order that was before the court. Again, the modification motion was not before this court.
Let me ask you just a question, Walt. So to get retroactive payments, you have the stats, you got to file a motion. Is there some, I mean, and I'm just trying to remember, is there some other way you can get retroactive payments besides doing this motion? Is there some equitable thing? It's like, didn't somebody raise in their brief some public policy thing or something?
Your Honor, I don't remember raising that.
You have to do that. That's the only way to get it.
Your Honor, and in this instance, we have a written motion.
I understand that. I'm just trying to, is there
No,
another way?
I am unaware of something outside of what's now defined by statutes, but we contend that the motion to modify that we timely filed right after the age-out event, which, interestingly, in reply to the motion, Ms. Berens admitted that my client's legal obligation to support Cecilia at that point terminated upon the emancipation. And so going to some notice points that the panel raised earlier on, it was crystal clear for more than 2 years that the age out of Cecilia was the primary motivating factor for modifying child support that my client was paying. And it's not just my client who has a child support obligation, it's also Ms. Berens. And Ms. Berens' child support obligation for Cecilia also ended back in May of 2018. And so with respect to the sentence, Your Honor, from Berens 4, I think the reasonable interpretation of that was a couple sentences before it talks about the modification motion. And the modification motion at that point said that Cecilia had aged out. What this court said in Berens 4 is that that modification motion that was filed after the fact, almost a year after the trial, didn't supply the information to the trial court to then base a determination in the permanent order. And so that may have given rise to the word file now. That's in that sentence. While we find that the trial court did not err in calculating child support for 3 children, husband may now file a motion to modify support in light of another child reaching the age of majority. If you take that sentence literally, then all of the things that Mr. Shelton said that my client could or should have done right around the time of the filing of the entry of the permanent order, this sentence would preclude that. It would only allow for the filing of a motion to modify after the mandate from Berens 4 issued in early February of 2020. And by that point, a year and a half or more had passed from the age-out event. It strains credulity to suggest that we have to play Twister to try to get relief on what everybody knows is a substantial change in circumstances. They don't even contend that it wasn't a substantial change in circumstances. They've conceded that point. This is all procedural gamesmanship to try to hold on to the money that my client overpaid for 2.5 years. And I think that the Supreme Court of North Carolina's recent decision in ME versus TJ speaks to this general principle that you ought to disregard the procedural machinations that Ms. Berens is undergoing and exalt substance over form and not form over substance. This is the opening sentence of the ME versus TJ case. For well over a century, North Carolina courts have abided by the foundational principle that administering equity and justice prohibits the elevation of form over substance.
I have one question about the statute. Maybe I'm just seeing it. It says each past due child support payment. He didn't have any past due child support payment. Why does the statute even apply?
Your Honor, are you talking about 50-13.10?
Yeah.
Your Honor, what specific portion are you looking at?
Letter A, it just says each past due child support payment is vested when it accrues and may not thereafter be vacated. It says past due child support payments. He didn't have any past due child support payments, so why does this statute even apply?
Your Honor, that's a good point.
Now I ask y'all the same. I'm just curious. It's just the plain language of that. Each past due child support payment, blah blah, may not be modified. And then we have the Supreme Court case that predated this that said you can do it and you don't need to.
That's right.
You have that. So that's the law. Except this, the General Assembly says if you have a past due child support payment, that can't be vacated. I mean, I'm just reading it. That just hit me. I don't think either one of y'all thought about that, but I'm just kind of curious about that.
Yeah, Your Honor, I guess in theory, the way this worked out in practice in this case, the permanent support order that was entered in July 2018 actually made the prospective child support of $5,400 something for 3 kids. It made it effective back to May of 2017. So it made the permanent support retrospectively effective by more than a year. And so rest assured, I think if they could make the argument that those were past due child support payments, I guess my client had paid $6,000 a month.
He was never
up to
late
that
on
point.
anything.
He did not.
All he's trying to do is get back money he paid. So he was never past due on anything.
That's right. That's right, Your Honor. He wasn't past due. And one of the instances that Mr. Shelton raised, where I guess we should have filed a motion for reconsideration immediately after the permanent support order was entered, there would have been 2 payments. And June and July of 2018 that would have come due in
So the
that
trial
interim.
court judge in this most recent order that's been appealed did not modify any payment that was past due.
That's correct.
Okay, that's okay. So I just was trying to figure out, I mean, nobody's really thought about that, just why this statute even applies. Okay.
Right. Yes, Your Honor. And in addition, under A2, it says, if the moving party is precluded by physical disability, mental incapacity, indigency, misrepresentation of another party, or other compelling reason from filing a motion before the payment is due. My client actually filed a motion before the payment was due, based on the operation of the retrospectively effective child support back to May of 2017. And so we think that we satisfied all the statutory and common law requirements.
Well, if we were to view this otherwise and vacate or reverse the child support part of the order, could you now file the motion and seek retroactive modification?
Your Honor, under 50-13.10, I'm not sure. I think Mr. Shelton said no, and I assure you we're going to run up against headwind if we try to do that. They're not going to concede that we can go back and get overpaid child support payments. And we'll run the gamut again, and we'll be back up here maybe again. So, Your Honor, I'm not sure how that would work out in the future. And that concept actually vitiates one of the things that Mr. Shelton says we should have done in this case back in the May 2017 trial, and that is to put into evidence the anticipated emancipation date of Cecilia a year later, and somehow have a built-in substantial change in circumstance, change in payment to take effect in the future. The law doesn't allow that. You have to look at the change in circumstances and look at the party's income at that point in time, the reasonable needs and expenses of the kids at that point in time, and whether Cecilia actually graduated from high school in May of 2018. Something may have happened and she had to go to school another year. She wouldn't have been emancipated in May of 2018 if that had occurred. So it's just conjecture and speculation to try to build in prospectively a substantial change in circumstance in that instance. And so we couldn't have done that.
Let me ask you one more question about the way I'm trying to read the statute.
Yes, Your Honor.
Are we bound by, there's a congressional act that I know that Judge Murphy read earlier. Is that something we're bound by too?
Your Honor, I think that is a overlaying binding, but this statute is what.
Because does that statute have different language than this? Because I'm still just kind of stuck on that each past due child support payment.
Your Honor, I do not have that statute in front of me.
Is this something where the federal government comes in and says, well, if you want this money for 4D or whatever, then you have to make these changes to your law, and here's what we want you to have. And then we want to say that you can't do this. You can't retroactively modify except in very limited circumstances, or you can't have jury trials with regard to paternity, and things like that.
Yes, Your Honor. I think that the General Assembly enacted this to make uniform with other states.
To be able to qualify for the federal funds?
That may be. I don't know the legislative history behind the federal legislation, but
I just seem to recall that back when President Clinton was in office.
Yes, Your Honor.
Going on.
I hear you. But we don't think, again, that 50-13.10 in any way undermines the process that we undertook to modify the child support in this case.
In your prayer for relief, you asked that the court modify the temporary child support order.
Yes, Your Honor. We also asked for any other relief that the court deemed just and proper, and also to establish a repayment schedule for overpayment and to set prospective child support for 2 children. So we asked for additional relief, and consistent with Rule 54C of our Rules of Civil Procedure, the court can grant whatever relief that the applicant is entitled. And there's a case that applied 54C, which facially applies only to pleadings, applied it to a motion. And so there's various instances. Ms. Berens' counsel attempts to draw the distinction between motions and pleadings, and I do recognize that oftentimes those are different things. Sometimes it's a little different in Chapter 50. You do things by motion in the cause, or a complaint. They're tantamount to each other. And so there's several cases that, indeed this case, she moved under Rule 12b-6 to dismiss our motion, and 12b-6 only applies to pleadings. The Stern case in which I was involved looked at a 12b-6 motion to dismiss a motion to modify child custody. So this court has interchangeably looked at motions to modify like pleadings in this context.
Well, in the domestic realm, isn't there often a choice as to whether you proceed by complaint or by motion in another action?
Oftentimes there is, Your Honor, yes, and 50-13.7, under which we moved, contemplates the motion. But it's stating a claim for custody modification. They try to dismiss that claim under Rule 12b-6, which they would say doesn't apply because it only facially applies to pleadings. They speak out of, it's inconsistent positions, in my opinion. Before I get into the Rule 15D supplement issue, I
want to ask one question before we move
Yes,
too
Your
far
Honor.
from this. Let's assume that we agree that, or agree with the appellant that the mandate rule may come into effect here on this language. You cite to Hayes and these propositions of being able to more or less ignore the mandate rule when the needs of justice are flexible. Has there been any determination of this concept applying Hayes in an equitable manner since the Supreme Court issued its opinion in re civil penalty, saying one panel of this court can't overturn another panel of this court? That's a big problem I have. If this concept were even still good law, is that something we can do or not? Obviously, they can always do whatever they want across the street and still follow this Hayes principle. But I'm not as convinced as we can. Even before in re civil penalty, we had basically a law of the case in re civil penalty here for about 5 or 6 years that we had to follow that. If it was the same parties and the same issues, another later panel couldn't go back on what that prior panel was saying. So we're looking at almost 40 years of jurisprudence that says, even if I think Judge Dillon said something else and meant something else 2 years ago, tough luck. So is there anything you can point to after in re civil penalty that would suggest that this court would have some type of power under Hayes?
Your Honor, I have not encountered that, and if the court wants supplemental briefing on that point, I'd be glad to do it. Would invite that. I'm unaware of a case that has applied that with respect to in re civil penalty. But again, I don't think we get there. I think that at most that statement was dicta in Berens 4 with respect to what Mr. Berens might be able to do. He may be able to do. Because again, if taken literally, then if he had filed a motion to modify on July 21st of 2018, and that was brought to the court's attention, and this court in Berens 4 said this, then Ms. Berens would argue by implication that Berens 4 precluded the trial court from considering a motion to modify filed the day after the permanent order was entered. And it doesn't make sense in that context. Again, I think that their position is we couldn't file a motion to modify based on this sentence until the mandate came down from Berens 4. It just, again, based on the language in ME versus TJ, it's placing form over substance.
Could you read my sentence again at the end?
Yes, Your Honor.
Boogie sentence. Read it one more time.
While we find that the trial court did not err in
No, the court may. Yeah, go ahead. Yeah.
I'm sorry?
The part that says that they may file a motion.
That's leading up. There's a comma and then comma. Husband may now file a motion to modify support in light of another child
Okay.
reaching the age of majority.
Okay, that's done. Okay. I don't have a
And, you know, Your Honor, there's still 2 more kids, and one of them's going to age out next month. And so maybe it's talking about another child. The parties had 6.
Yeah, that was what I was thinking. I was
And
wondering.
so there's no preclusive, prohibitive language in that sentence. Again, which, when you think of the mandate rule, you're thinking about, you're telling the trial court what to do on remand, and then if the trial court does something that is contradictory to that, then they violated the mandate rule.
I have your mandate argument. Talk to me about the, what your friend over here said about the lack of evidence on what wife was making. Because I think there was something in your brief saying, and I'm trying to remember the numbers, well, you know, our client guessed it was about 147, we're only $6,000 off. Where did that, I mean, $6,000?
Your Honor, there was, there was, Mr. Berens testified, I believe, that there was $146,000 in income. And then there's the cutoff in testimony, and then we pick up somewhere in the middle of Ms. Berens' testimony. And in Ms. Berens' testimony, she is saying that he doesn't know what's going on.
Is there any evidence in the record before us that she made 141 or whatever that number?
She admitted that in the transcript, and I don't have the transcript page reference in front of me, but it's in our brief. Actually mentioned the page where she said it's within $6,000 of what he said. And
Okay, that might be competent evidence. Okay.
yeah,
And I'll ask them why that.
Your Honor, he wasn't just grabbing from
What did the
Zillow.
trial court judge find? Did they find it was within the 6,000, or did they find it was 146?
Your Honor, it's not broken down that way. I'm not sure if it used the 146 or 140 number in determining her gross income for 2019 and 20. But it was in line with that. I don't know which. It was 140 or 146. But it was certainly different than what was on her financial affidavit. And they talk about my client not just speculating about what she may or may not have made. He didn't just look at Zillow. He looked at bank records. He looked at tax returns for her new business, the realty business that she had started. And it wasn't just taking, oh, they just get 3% and that's what we take as gospel.
Yeah, talk about the 3% thing. Where did the judge come up with the 3% number?
Okay, there was two references to 3%. The 3% I'm talking about is the commission and the sale of a house.
I understand that, and I'm past it now.
You're past that.
I know.
Okay, so you're talking about the 3% rate of return on the 529 account monies. There is no testimony in the record that I can find
So
that mentions.
Is she right about the law? You got to have some evidence.
Yeah, Your Honor, and I think that's a problem with a gaping hole in the transcript. There could be evidence. I don't know. There could have been evidence
Well,
in.
that's my initial question. Was it her burden? Did she lose that argument because she didn't put all the evidence in play, or was it your burden to say, you know, I don't, because I guess when you're putting the record together, you don't know what she's going to argue on appeal, and so you don't know. You don't.
Yeah, Your Honor, it gets a bit circular when you get into this
I know, so I'm trying to-
situation.
What are we supposed to do with that?
Respectfully, in the appellate practice treatise that are written by 2 of my esteemed colleagues' partners, they talk about this issue, and it's in our memorandum of additional authorities.
I would think the burden would be on you once she raises the argument, say, hey, I want to supplement the record and show you in the record where it's in there. I mean, I would think. I don't know how else you would do it. Because you don't want to have to print everything if it's not necessary, but you wouldn't know what's necessary until she makes her argument. So it's not really fair to say that you left it out, but if she makes the argument and she says it's not in there, why wouldn't you just move to supplement the record, I guess?
Yeah, Your Honor. In this instance, I can't supplement the records. It's not like a document left out. I would have to go back and do a narration. They would have to do a narration. We'd have to have judicial settlement of a narration in the trial court if there
So
was
there's
a
not
dispute.
there's not a transcript that there was 3%. There's not. It's not
No, there could have been testimony about 3%. That's what I'm saying. But we don't know. And just to close the loop on the duties of appellants and appellees, in the treatise, they say both parties also have a duty to review the transcript for errors and request that material mistakes be corrected. Likewise, both parties have an obligation not to include unnecessary materials in the record, including duplicative documents. Actually, it's just above. They say, however, the appellee has no obligation to correct deficiencies in the record on appeal that might prevent the appellant from proving its case on appeal. And that's the exact instance
Well,
we have
whenever
here.
you make any argument that there's not evidence to support X finding, would that always in every case then be incumbent upon the appellant to include the whole shooting match if it's 1 million pages of testimony that has nothing to do with it, but they got to include it because there's no way then we could ever figure it out, because you have to look at the whole thing to show that it's not there.
Yes, Your Honor. I think that
Because you're now saying that you think there might be something there, I guess that, I don't know, I mean.
yeah, I do think there could be something there. And oftentimes when this court has looked at it in the context of either criminal cases or it's looked at how much it looks like might be missing from the transcript. And in this instance, until I dug into the actual insufficiency of the evidence arguments they were making, when I was reading the transcript, I was like, it jumps from Mr. Berens' direct testimony into her testimony, I believe. It maybe, but there's clearly a large gap in between where it cuts off. And
Yeah,
then,
but if there's something in that gap that says that 3% is a good interest rate, I would have thought you would say, raise your hand, say, I want to amend the record, include this part of the testimony, you know, because if there really is something there.
Your Honor, and I guess I would have done that after receiving their brief, because I didn't know whether that argument was going to be
You
made.
get their brief, and then they might be in trouble for hiding that from us if they knew it was in there.
I'm not
don't know.
suggesting that they're hiding anything.
No, I know.
I'm really
I'm not saying they are. I'm just saying, but I mean, I'm not saying they, but hypothetically, I would go term. But I'm just saying, would you, if it's in there, I'm just saying, why would you file a motion to supplement the brief? I want to include these. If it's all in a transcript, I don't. If you have I mean, I don't know what's in there, but.
I understand, Your Honor, and neither do I.
And just so I'm completely clear, I haven't dove into particulars, they're not a transcript because it was not all transcribed, or that part of it was inaudible? This is a domestic case, I'm assuming it was put on a CD in the district court, so there wasn't a stenographer there. But is it because it's inaudible on the disc and it could not be transcribed, or it was just not transcribed, or if it was transcribed, it was not made part of the PDF that got uploaded?
Your Honor, there is a notation in the transcript itself by the court reporter. I don't have that in front of me, but in essence, it's not inaudible, but it's something along those lines. And then there's the jump from Mr. Berens' testimony to somewhere in Ms. Berens' testimony. And so it wasn't, we left out pages 220 to 225 of the transcript. It wasn't transcribed. For a reason.
So similar to the issue we see oftentimes in some DSS cases and other cases of that kind that we've had to address.
Right, Your Honor. And the, I see I have 20 seconds left.
No, you got time. Go ahead.
Okay. In the NRA RN case, it talks about, and we included that in our memorandum of additional authorities. It's the 6th decision. And it talks about, while each party has duties to make sure that there's an accurate record, when there's a problem, you can't then try to take advantage of it as far as like, and in this sense, I would
So
think.
you're saying they're taking advantage of it because they know there's something there and they intentionally have that?
I'm not saying that what I'm saying is they're trying to take advantage of it by way of making arguments that there's insufficient evidence to support various findings, when there is the possibility that there is testimony that actually does support those findings. I'm not casting any aspersions on them. I'm not.
I just think we got arguments all the time. There's insufficient evidence, and we don't have all the depositions. We don't have every page of everything. I mean, that because it's just too expensive, and there's no need to put it in there. And that But if it's there, I would think that the appellee would file a motion to say it's really there once they see the argument that's been made. So, I mean, we can only speculate whether it's there or not. I mean, but you're saying they waive any argument if we don't have the whole record.
Yeah, I guess the
I mean, that's basically the rule you want us to adopt, that if you don't include the whole, if you ever make an insufficient evidence, if you don't include the whole record, you just waive it, because there's no way we can tell.
Your
Or-
Honor, I think that would, I'm sorry.
Well, I was just going to add, or not just if you don't include it, but if it's not available.
Right, and that,
Yeah.
and that happens. In the RN case, it says, as our Supreme Court has cautioned, defense counsel and district attorney, this is in obviously the criminal context, as officers of the court have an equal duty to see that reporting errors in the transcript are corrected, and then it emphasizes, this duty does not, however, embrace the right to perpetuate and then take advantage of transcript mistakes. And I guess it could be which foot is the shoe on in this instance. I would argue that when you make sufficiency of the evidence challenges, and the trial court's ruling comes up here with a presumption of correctness as a start, then it ultimately is the appellant's duty to bring forward the evidence or the body of evidence to then for the court to ascertain whether there actually is evidence in the record to support what they're saying. And oftentimes, it's pretty easy to tell that it's just a de minimis transcript, an inaudible in a sentence, and it's in the middle of testimony, but not what looks to me like a large gap in the testimonial evidence.
And take about 3 minutes. I will give you 3 more minutes to wrap up.
Okay. All right. Let me touch on the 15D argument. I heard for the first time today that a supplemental pleading could not relate back. I don't think that's the law. They don't cite any law in their brief on that, and I think that it does actually relate back. And we're not saying that the reason for the supplemental motion to modify was because of the age out of the child. It was because of the entry of the permanent order that happened after we filed the motion to modify. That was the event that gave rise to the supplementation. And so it does fit within the parameters of Rule 15.
So 15 applies to motions and pleadings.
Your Honor, we believe so in this context, just as Rule 12b-6 would.
Is there
and
a
Rule
case
54C.
Is there any case that says that?
No case has addressed that, Your Honor.
Okay, I'm just wondering. Either way, I just wondering.
Yeah, no case addresses that. But again, in this context, motions are oftentimes treated as pleadings. And we think it should in line with the principles of ME versus TJ. With respect to the 529 account issues, just a couple points. The trial court did not mandate, either with respect to 529s or UTMAs, that they be used. That actually happened in the temporary order and in the permanent order, about which they didn't complain. And the reason that the UTMA and 529 accounts are being used for educational expenses are because that's what the parties did. There's a finding in the permanent, actually in the temporary order, that was what the parties did while they were married. That was the accustomed standard, and no party attempted to include private school tuition in the reasonable needs and expenses of the child until on remand from Berens 4. They had always been taken out and been taken care of by the UTMA and 529 accounts.
But wasn't tuition and car insurance included as part of the children's reasonable monthly expenses?
No, Your Honor. It was not in the permanent order. They were to be taken care of. Well, car insurance, maybe, not the private school tuition. That was excluded, and it was actually in the transcript, in the permanent order, I believe it's finding number 115, something like that. And so, again, that was off the shelf from the reasonable needs and expenses, and we suggest that what Ms. Berens was doing on remand was to try to get her own modifications by then putting those back in, or inserting those as reasonable needs and expenses of the children. which they hadn't been throughout the entirety of this case.
Question about 529 plan you may or may not know the answer to. Are educational-related transportation expenses deductible from a 529 plan?
I don't know, Your Honor.
Okay.
I don't. And one last thing, there's to clear up the issues with respect to the $640,000 that's referenced with respect to the 529s, and there's another $628,000 and change number. Those are different. It wasn't a confusion by the trial court, as Ms. Berens suggests. There was actually $628,000 paid to Ms. Berens in 2020 after remand from Berens 4 based on the stay that had been in place during Berens 4. And so she got $628,000 in 2020 on remand from Berens 4, separate and apart from the $640,000 that were in the 529s. And the interest that's accruing, the trial court took that 628 into account as well, as it should have, in assessing the estates of the parties. And with respect to the UTMA accounts, 50-13.4C requires the court to look at the estates of not only the parties, but also the children in fashioning reasonable child support. And we suggest that's what the trial court did here, as it had in the permanent order and the temporary order.
And one more question, and sorry.
Yeah, Your Honor.
This might be simple,
You're fine.
but with the 3% interest, not the commissions, the interest that she was credited with for income, that was based on her separate estate, correct?
Yes, Your Honor.
Okay. Did the 529 plan or any other documents on investment accounts show anything related to a rate of return over the same period? So you say, even without any testimony about the rate of return, that the trial court could have imputed a same reasonable rate of return that was being seen on the 529 plans and pasted that on to her investments, and whether she was getting that return or not, she could have been.
Yes, Your Honor, but I have not done an analysis on the 529 statements to see if you could infer that from the 529 statements, but that's definitely possible. I could see that. If Your Honors have nothing else, I'll take my seat.
Thank you.
Thank you, Your Honor.
Your Honor, I'm not sure if I have any rebuttal time, but if you'll indulge me, I promise to
You
be
got
brief.
7 minutes.
Okay.
You got your 7 minutes. My watch goes slow, so in this case, this is interesting. Go ahead.
I'm primarily going to just address the retroactivity problems, but I do want to say just one thing about the transcript issue. First, stipulations matter, and Mr. Berens stipulated that the transcript was complete. And he knew that we were going to raise this issue. If you look at page 562 of the Record on Appeal, we list our proposed issues. Proposed issue 32 said, did the trial court err by assigning income to defendant by finding a 3% return on investment when no evidence was offered to support the percent return at any amount? So he had all the notice that he needed that we were going to make that sufficiency argument when he entered into the stipulation about the transcript. Now, turning to the retroactivity problems, Your Honor, if Mr. Berens didn't like the sentence telling him to file a new motion on remand, he could have filed a motion to reconsider in this court. As you know, Judge Dillon, Your Honor, we have filed a motion to reconsider in cases before you, and I know that you're happy to grant them.
Talking about this, the wording of the statute says each past due child support, and the title of the statute says past due child support vested, not subject to retroactive modification. It seems like the statute's talking about past due child support.
Your Honor, I think it's past due in the sense of it's simply a child support obligation that comes due. So if you actually turn to the federal statute, it doesn't use the phrase past due at all. It just says there can't be a retroactive modification of a child support obligation. So I think you have to read those statutes together, because the state statute, in fact, if you look at the session law that we cited, says we're just following this to implement the federal law. So I think that is the sense in which it is a past due.
I want to go look at the federal law because I'm curious about it, because, I mean, I used to be in banking, and past due just has one meaning. It's a payment that was due that had been paid.
Yes, I understand that, Your Honor. I just think
But we do have to comply with the federal law, I guess. I need to understand that. So you're saying the federal law doesn't make that distinction?
I don't think it does at all, Your Honor, and I do invite you to check out that statute.
Has that statute ever been interpreted that way? Because, I mean, this is not a new statute.
Your Honor, it is shocking how few cases have cited this statute.
It's shocking how few people know about the exceptions.
Yes, Your Honor. So, no, and no, because no one never hardly ever cites the statute.
Okay.
So I don't think there's much to infer one way or another from the absence of authority there.
Let me
Judge,
ask one question real quick, just follow up from Judge Zachary's question. Was the language that appeared here part of a model act at all created in response to the federal legislation, or was each state, do we put it into place on our own in our own drafting, or was there a model act at all in place that we, whether we do or not, theoretically, sometimes our cases say we can look to other interpretations for other states using the model act. Was it any idea if this was a model act type of statute?
Your Honor, I don't believe so. So I think it's unique to North Carolina. So it's not like the UTMA where we say the General Assembly has insisted that you please do look at other jurisdictions so there will be uniformity in the law. And I don't think that this was that kind of statute. Judge Murphy, you asked whether whether the court could sort of take equitable considerations into account and sort of give the back of the hand to the anti-retroactivity statute. But this court has already said in Craig versus Craig that you can't do that. This court said previously, this court held that a trial court may retroactively modify child support arrearages when equitable considerations exist, which would create an injustice if modification is not allowed. And the next sentence is, these cases, however, were decided before the anti-retroactivity statute became effective. That statute is, I understand that we are making a formalistic argument. It's a highly technical formalistic statute. It requires not just a motion, but a written motion, and it requires notice.
Do you have the statute in front of you? Because I want to talk to you about the language in A, some more language.
Yes, Your Honor.
It says, it talks about a past due child support payment. We can talk about that. Then it says, except that a child support obligation, which could be any obligation, may be modified as otherwise provided by law. Does it stop there and then the rest of it's on its own? And a vested past due payment to the extent that is to that extent subject to divestment if a motion's filed. Now, I'm looking at the first part. Does the normal child support payment that can be modified otherwise provided by law require a motion or not? Or can it just be as required by law? Could there be some other law, that first part? Except that a child support obligation, which in my mind could include past due child support payments and maybe those that aren't. Maybe I'm just trying to understand why they have two different clauses here. Except that a child support payment may be modified as provided by law, and then it goes on to say an invested past payment can be subject to divestment if a written motion is filed, blah, blah, blah. So I'm trying to figure out the motion part, is it attached to both those phrases or just the vested past due payment?
I think you have to read the two phrases together, and they're not totally separate. And that's why they say is to that extent subject to divestment. That I think is pointing backwards to, we're talking about the modification of child support obligations. Now, I'm not here to say that this statute stops someone from increasing child support payments retroactively. That might be some other problem of some other statute, but that's not the evil that this statute is designed to cure. It's saying, if you want to file that motion, that's fine, and we will retroactively go back to that motion. But my friend's argument is essentially like, well, this statute would never doesn't come into effect if you're just seeking a refund of overpayment. But I think the statute, I think maybe that's really the central issue here. Then this statute absolutely does apply, even if you're seeking a refund of overpayment, even if you paid the obligations as they came due. That's, I think, the fairest reading of the statute. I think that's the reading of the only reading of the statute that is consistent with federal law.
Well, yeah, I'm going to have to see the federal law because, past due does that. They use the words past due and it has a meaning, but I'll look at the federal law. That's fair.
Your Honor, I want to know one other thing that my friend on the other side said. He said, well, we couldn't have put this evidence in at the 2017 hearing. What he could have done at the 2017 hearing is avoided this problem altogether by saying, I want you to allocate child support for each child. That's not what happened in this case, but he could have asked for that. And then he would never need to file a motion at all. It would have been automatic. And so that's just another problem of he blames Ms. Berens, but Had he simply asked for that, he would have gotten it. He never would have had to file a motion.
But you don't waive the right to file a motion just because you don't do it. You can still file your motion, but you're saying that maybe not in this case. but-
If you have it allocated per child prospectively,
motion.
you don't have to file a motion. It's automatic.
Is there any requirement that the trial court do that, or is it in the trial court's discretion whether to do a total or individualized at that point? Because I'm thinking, you know, if part of that's going to include housing costs, that doesn't change much if you got 2 or 3 kids versus, you know, private school if you're going to provide for those kind of things. So is there an actual requirement for the trial court, if requested, to make individualized assignments, or is it within the trial court's discretion?
I just want to be frank and tell you, I don't know the answer to that question, Your Honor.
You have 2 minutes, and then you can to wrap up.
Your Honor, unless y'all have any other questions for me, I do want to just remind the court that we listed 5 things that he could have done, either before or after the permanent support motion order was entered. And staying here today, there's still not a motion to modify the permanent support order. So, you know, Mr. Berens has a lot of blame for other people, but I think a lot of the blame of the situation rests on the decisions made by Mr. Berens. And we respectfully ask that this court reverse and remand. Thank you, Your Honor.
Thank you all for your arguments.
Thank you, Bill.
Sorry if I kept y'all too long, but I appreciate you answering our questions and everything. We'll take it under advisement, and we'll adjourn.
That's wild. I told Michelle, I said, I think Judge Dillon just gives out time. You don't know before you get here what it, you know, 5 issues, what they care about.
It says right there, it's transcript interrupt.